Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we have a couple of very interesting cases set for conference this Friday before the United States Supreme Court. That's Friday, December 5th. We're going to get you educated about both of them. I honestly don't believe either of these two petitions really have a chance of being accepted, but the issues are one that we need to put on our radar and we need to keep them there because ultimately these are issues that has to be resolved by the United States Supreme Court. We'll explain it all in just a moment. So today, let's spend a few minutes, let's get you educated, and let's talk about the two issues before the Supreme Court that disarm Americans every day. Okay, America, we're going to talk about two very important legal issues that are unresolved in part due to intellectual dishonesty by lower courts, but I digress. But these are issues, and we'll explain how, that are used to disarm millions of Americans on a daily basis. What am I talking about? I'm talking about two cases. The first case is the matter of Perez versus the United States. It comes out of the Second Circuit. This is a challenge to a conviction for unlawful transportation of firearms across state lines in violation of 18 United States Code, Section 922A3. We'll circle back to that in just a moment. The other case, and we've talked about this case a couple of times already, is the matter of Morgan versus the United States out of the 10th Circuit, a challenge to 18 United States Code, Section 92201, the federal prohibition on machine guns. Now, these are really good issues that come in very bad vehicles. What do I mean by that? I mean that I'm not going to get into the facts of either one of these cases because, well, candidly, like Rahimi, like Hamani, they don't really present well. And so, again, I don't think these are particularly good vehicles to resolve the issues that we're about to talk about. But the issues that need to be resolved are of critical importance to all gun owners nationwide because the issues addressed, one in each of these cases, is as follows. Number one, does the Second Amendment protect the right to acquire firearms? Number two, what really constitutes an arm for Second Amendment purposes? Okay, let's first start with Perez and this whole issue of, does the Second Amendment constitutionally protect your right to acquire a firearm? Now, I know many of you sitting there going, well, duh, of course it does. Yeah, except guess what? In a lot of courts, that's not the case. Take, for example, in Perez, where the court ruled that an individual's acquisition of firearms was merely an ancillary Second Amendment right, and therefore the court could apply a meaningful constraint test similar to what the Ninth Circuit had done. And listen, when you are relying on Ninth Circuit precedent to rule on a gun case, you know that things have gone completely sideways. But what the court's ruling then allows them to do by injecting this interest balancing test back into the acquisition of firearms is rule, regulations on the means of acquiring, transporting, and storing firearms only implicate the text of the Second Amendment if they meaningfully constrain the right to possess and carry arms. So if the Second Amendment only protects the right to possess and carry arms, and there's no protection whatsoever for the right to acquire, obtain, accumulate firearms, what happens when you live in one of these states right here? And the reason I mention that is because the actual issue presented in the Perez petition is, does the Second Amendment presumptively protect an individual's right to acquire firearms? And it frames the secondary issue as, is the meaningful constraint standard applied by the Second and Ninth Circuits to determine the constitutionality of regulations concerning ancillary Second Amendment rights correct? Because if we do not put up some type of constraint to regulation of how we acquire, accumulate, or obtain firearms, then there are a dozen states, at least in this country, that will put up every possible barrier known to man to make sure that individuals cannot acquire firearms. Okay, now, like I said, I've been through the entire petition. I agree with large chunks of it. There's one part I do disagree with. In general, what the petition is claiming is this. This court should grant the writ in order to resolve two important questions: whether firearm acquisition is conduct protected by the Second Amendment, and whether the Second and Ninth Circuit's meaningful constraint legal standard for ancillary Second Amendment rights is correct. I agree wholeheartedly with that sentiment. Where I tend to disagree, however, with the petitioners is this. Petitioner's case provides an ideal vehicle for resolving these questions, and given the paucity of law on these issues, the Second and Ninth Circuit's adoption of this standard will likely prove influential. I do agree that the Second and Ninth Circuit's ruling on this could prove to be influential, but the part about this case being a good vehicle, I could not disagree with anymore. And if you don't believe me, we'll go ahead and link up everything about Perez down below so you can see what the allegations were against the petitioner. But America, this is a very, very important issue, because if we don't put up some type of constraint on what government can regulate as it relates to how we acquire firearms, then it is only a matter of time before many states, most of them on this list right here, make it absolutely impossible for a person to actually obtain a firearm and thus exercise their Second Amendment right. Okay, an equally important question, of course, is what actually even constitutes an arm under the Second Amendment, and that's an issue posed in the matter of Morgan versus the United States, which comes out of the 10th Circuit. Now, the issue presented in that petition is whether a handgun and handheld pistol that fire automatically constitute arms under the Second Amendment's plain text, thus requiring the government to justify the machine gun possession prohibition under 18 United States Code Section 922.01 by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. And so you see, that is the central question here, is what actually constitutes an arm under the Second Amendment? And this is why it's so critical, because for many of these challenge statutes in which there is absolutely no historical justification whatsoever for it, what courts are doing is they're merely finding that the Second Amendment's text doesn't cover the activity, and therefore there's no reason for historical analysis. And you sit there and you go, wait a second. How can an automatic weapon not be considered an arm? I mean, arms are defined under clearly delineated case law as arms are weapons of offense or armor of defense, anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. And while that definition may seem pretty obvious to all of us, the lower courts continue to struggle with it, causing the petitioner to point out, as relevant here, the lower courts are conflicted over how to determine whether specific weapons qualify as arms under the Second Amendment's plain text. Now, if an arm is something that we can take in our hands and then use either in offense or defense, wouldn't all bearable arms, automatic or semi-automatic, fall under that definition? And as the petitioner wisely points out, in D.C. v. Heller, this court logically stated that all firearms constitute arms under the Second Amendment. Yet below, the 10th Circuit held that Tamori Morgan's handgun and pistol did not constitute arms under the Second Amendment's plain text because the firearms could fire automatically. And again, for all of these courts that are trying to avoid this part of the equation over here, is there historical analogs to justify this regulation? They are doing so by finding that there is no application of the Second Amendment right here in this part of the equation. According to the 10th Circuit, Morgan's firearms would constitute arms under the Second Amendment's plain text only if he could prove that the firearms are in common use today for self-defense. And because Morgan could not meet this burden, his firearms were not arms under the Second Amendment's plain text. Now, this is a workaround of the plain text analysis that probably did not need to be engaged in by the lower court. They could have easily found that automatic weapons, like all firearms, are in fact bearable arms, and therefore the Second Amendment actually is implicated. They could have further found that, well, there's already been a historical analysis done, and when it comes to platform bans, the only thing that we can ban are those that are dangerous and unusual. They then could have made a finding that machine guns, automatic weapons, are dangerous and unusual. We could debate about how unusual they truly are, but that could have been their finding, and at least they would have answered the question within the confines of the correct legal analysis as announced by Bruin. But instead, no, they've done this end around, and it's not an end around that's exclusive to this court. We have seen time and time and time again. State of Washington and Gators guns, high capacity magazines are not even arms protected by the Second Amendment. We see this with all sorts of other firearms. We got the 7th Circuit ruling that the semi-automatic rifle in the AR-15 platform is not even protected by the Second Amendment. This insanity does need to stop. The case of Morgan versus the United States will attempt to do so, but once again, as you can probably tell by this set of facts right here, whether a handgun and handheld pistol that fire automatically constitute arms, we can probably figure out what type of activity Morgan was engaged in, thus again making this a really, really poor vehicle to resolve this issue. But at the end of the day, America, there are two huge issues that are being addressed in these cases that do need definitive answers by the United States Supreme Court and in the very near future. Once again, they are number one, does the Second Amendment protect the right to acquire firearms? And number two, what really constitutes an arm for Second Amendment purposes? And until the Supreme Court steps in and gives very clear guidance on these issues, these are the exact tools that lower courts hell-bent on upholding civilian disarmament will continue to use to uphold these unconstitutional laws. Okay, listen, we'll go ahead and link up both petitions down below. The cases, once again, are Perez versus the United States out of the Second Circuit and Morgan versus the United States out of the 10th Circuit. Once again, they are scheduled for conference this Friday, December 5th. We are doing a live update Monday morning, bright and early Monday morning, to go over the orders list when it is published, 9:30 on the East Coast, 6:30 on the West Coast, Monday morning. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everybody remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.